Okay, thank you, everyone. Thank you for your patience on Zoom just while we were whipping everyone in from the tea and the coffee. Good evening to all of you, and thank you to all of you in person who've made it today after battling through some pretty fierce weather out there. I hope we can make it worth your while. I'm sure we will. For those of you who don't know me, I'm Nick Austin, a partner in the shipping team in the London office of Reed Smith. And on behalf of the firm, and in particular the shipping, the sanctions and the commodities and trade team here, it gives me a great pleasure to welcome all of you. And of course, to everyone joining us online, 58 of you, it tells me here, to tonight's London Shipping Law Centre event, which we're absolutely delighted to be hosting for the LSLC. As it happens, I also have the privilege of serving on the council of the LSLC, so I'm pleased to welcome you with that hat on as well. We have ahead of us this evening what I'm sure will be a fascinating event, concerned as it is with the ever-present and fast-changing sanctions landscape. And as you'll see, we have a really top-notch panel and a top-notch chair to guide us through that. I hope also that those of you here in person will please stay at the end for a drink and something to eat, if only to steel yourselves for facing the elements once more when you leave. A couple of housekeeping issues related to the Zoom. We're very happy to take questions at the end in the Q&A session, which will be 15 or 20 minutes or so before we break for drinks and canapes. If you do have a question on the Zoom, please put it on the chat and I will moderate those later and pick out a couple of questions if we have the time to put to the panel, as well as those, of course, in the room for whom we have a mic that Johnny will hand around. We may not get to all the questions, and could I please remind everyone on Zoom to keep yourselves on mute so we don't get any unwelcome interruptions. To steer us through our discussion, I'm delighted to welcome our chair this evening, Mr. Justice Andrew Henshaw, who will in a moment take the reins from me and introduce the panel. But before that, it's only right that I introduce him. Mr. Justice Henshaw has been a judge of the Commercial Court since 2019, where his work includes dealing with shipping, insurance and arbitration cases of all types. He also sits in cases in the Administrative Court, the Crown Court, and the Criminal Division of the Court of Appeal, so watch out. Prior to that appointment, he practiced as a litigation solicitor at Linklaters from 1984 to 2000, becoming a partner in 1994. He then moved to the bar and practiced from Brick Court Chambers from 2000 until 2019, specialising in commercial and banking derivatives, litigation and arbitration, public and EU law. So no stranger to sanctions, I'm sure. Andrew was appointed to QC in 2013 and a Deputy High Court Judge in 2017. With that introduction out of the way, we're delighted to have all of you here and to have you here, Andrew. And with that, I'll hand over to you.
Thank you very much, Nick, for your kind introduction. So welcome to everyone here, including everyone attending remotely, to this London Shipping Law Centre seminar on the subject of sanctions. I'm sure it'll be a timely and useful event. May I introduce our distinguished panel. Alex Brandt, to my left, is a partner in the Transportation Industry Group at Reed Smith and head of its sanctions practice. Alex advises insurers, owners, charterers, brokers and traders on all aspects of sanctions-related challenges, extending to due diligence work, OFAC investigations and disclosures, and drafting protective language. He's here in contravention of the terms of his paternity leave, having just become a father third time round. Sara Masters, on my far right, is a barrister and arbitrator practicing from 20 Essex Street Chambers. Her practice areas include shipping and international commercial litigation and arbitration, and she appears regularly before courts, the major arbitral institutions, and trade-specific bodies, including the LMAA, GAFTA, and FOSFA. Sara also has experience in the rapidly changing world of commercial sanctions, both as counsel and arbitrator, with a particular focus on Russian and Iranian sanctions in the transport and energy sectors. Sandra Rosignoli, to my right, is Group General Counsel and Head of Compliance at Clarksons, a leading player in maritime consultancy, shipbroking, and shipping intelligence. She covers the full range of the group's activities and deals with sanctions on a very regular basis. And finally, Angus Galloway on the far left, for me, is Legal Divisional Director at Clarkson Group and covers all areas of in-house work with a specific focus on sanctions and compliance. He's very kindly stepped in at short notice to replace another industry rep who was unable to attend. So the format is that we'll take our 6 advertised topics in turn. I'll invite a member of the panel to lead off with others joining in. And we'll then, as Nick mentioned, take questions at the end. So I expect the total session will last about 90 minutes, followed by drinks. So on to question 1. Does Putin control everything in Russia? The implications of the Court of Appeal's decision in the Mints case. And as a rider to the Mints case, we now also have the Foreign and Commonwealth Office's statement, which Sandra is going to come to, but that's a statement issued on the 16th of October, the general gist of which is to rather downplay the significance of the sting at the end of the Mints case, which deals with a control issue. Despite all of that, Mints is currently still being cited quite often to courts and arbitrators. And there was also a recent rumour that operations at the LME were being affected. So can I first of all ask Sara Masters whether we should be concerned about the Mints case?
Thank you. Thank you very much, Sir Andrew, for that excellent introduction. The Mints case. Now, I'm going to set the scene to start with. The case, in fact, isn't a sanctions case in told at all. It's a commercial fraud case, and it's a case where the claimant to Russian banks are suing the defendants on the basis that they have conspired with representatives of the bank to defraud the bank. The sanctions issue arises because one of the claimants is designated and the other claimant is not designated. That's the National Bank Trust, but it's 99% owned by the Central Bank of Russia, who are also not designated, but they themselves are controlled, firstly by the governor of the Russian Central Bank, a woman called Miss Nabiolina, and also, and this was accepted by the claimants, by a certain Mr. Vladimir Putin. Now, the sanction issue arose as follows. The defendants made an application. So the claimants bring the claim. The claimants, as I say, one of them is sanctioned. The defendants bring an application and they say, right, it's all got to stop because judgment can't be entered in favour of a sanctioned individual. One of you is sanctioned and the other one of you is owned or controlled by a designated person, by a sanctioned individual. And this was on the basis that, assuming that one was designated and the other was owned or controlled by a designated person, that the entering in of judgment would amount to making funds available or making economic resources available to a designated person. Now, it led to quite an interesting argument in the commercial court, I think, for a couple of days in front of Mrs. Justice Cockerell. And she rejected the defendant's case, essentially, and she held essentially that although she held that a judgment debt was a fund and a cause of action could be an economic resource, she held that the mere entering in of a judgment was not a breach of the sanctions, because it wouldn't constitute dealing with an economic resource. Now, she said, as in thank you, Sandra, as in much the case in this area, that the legislation was Delphic, to say the least. A lot of it has been put together at great speed, and I'm sure many of you are aware of a number of idiosyncrasies, lacunae, and plain bonkers stuff in the legislation, but she held that in order to have this effect, it would amount to a grave restriction on the access to justice of a litigant, first point, and also that the principle of legality meant that unless the legislation was very clear, that she was not satisfied that the entering in of judgment would amount to dealing with an economic resource and therefore violate sanctions. Okay, all good. Now, as an obiter aside, she dealt with a question as to the final subparagraph of Regulation 7 of the applicable regulations, which deals with the meaning of owned or controlled by a designated person. Now, Regulation 7 is in several parts, and what it starts off with the relatively simple cases where it says that a company A may be owned or controlled by a designated person by virtue of shareholdings, voting rights, control, in terms of governance, so paper stuff. But then there's the final, particularly Delphic provision, which states that a person who is not an individual who is owned or controlled by another individual and this is, if it is reasonable, having regard to all the circumstances, to expect that P, that being the designated person, would, if P chose to be able in most cases or in significant respects by whatever means and whether directly or indirectly to achieve the result that the affairs of C are conducted in accordance with P's wishes. Now, this is what has led to the Putin controls everybody problem in Russia in the Court of Appeal. Now, Mrs. Justice Cockerell held that this didn't amount to give where circumstances didn't apply to control that was simply political control, that it wasn't intended to cover that, and merely by the fact that in a state such as Russia, it could be said that Putin had significant political control. That wasn't what it was intended to deal with. She didn't really quite work out what it was intended to deal with, but it wasn't intended to deal with that. Now, the matter went to the Court of Appeal on the first question, and I'll say probably later that this, I think, is also important in the arbitration context. The Court of Appeal, which was Flo, the Chancellor, Lord Justice Popperwell, and Lord Justice Newey, so a pretty strong court, they followed Mrs. Justice Cockerell. So again, entering in of judgment by a sanction claimant does not violate sanctions. Now, then on the other issue, which I say was obiter, so they didn't have to decide it at all, but nevertheless, fascinated as they were by the question, they couldn't stop themselves from having a go. And they disagreed with the Court of Appeal. And they said that given that it had been conceded that the National Bank Trust was controlled by Mr. Putin and or Mr. Nabulina, and given the fact that, as Mr. Justice Flo colourfully put it, Mr. Putin as at the apex of a command economy, in those circumstances, in a very real sense, and certainly in the sense of Regulation 7.4, Mr. Putin could be deemed to control everything in Russia. Ms. Nabulina is the governor of the Central Bank of Russia, which owns 99% of NBT, and her political office reports to Mr. Putin as president. So as a result, they did recognize that could give rise to absurd results, and it could lead to real difficulties for stakeholders and economic operators. But they said, well, that's a result of the government legislation, which is clear, and it's for the legislator to put it right if they want to, and not for the judges. So there we go. So what do I think about it, and where does it leave us? I think that either the Court of Appeal has got it wrong, or that the legislation is very badly drafted, or a mixture of the both. But wherever it is, it has led us in a difficult position, which I don't think users in the market and stakeholders deserve, frankly. I think that's my big bold point. It is obiter, but it's a strong Court of Appeal. It's not clear. I've been trying to find out if permission is going to be given to go to the Supreme Court. I'm not sure if it has yet. If it does, if it isn't, it may be. On the first question, I think that the position is pretty clear, and that Mrs. Justice Cockerell and the Court of Appeal got it right. On this question, so maybe the Supreme Court thinks, well, we're not going to enter into this. Alternatively, they too may be fascinated by the question or think that they need to get it right. And in the event that they give permission on the first issue, it may be possible that the other side can cross appeal on this point, so it will go before the Supreme Court. In the meantime, and subject to the Foreign Office clarification, guidance, note, whatever you call it, we are stuck with it. In terms of what the Foreign Office have said, interestingly, prior to Mints, they had come out with a statement, and this was apropos to something completely different, that the governor of the Central Bank of Russia did not control, was not owned or, that the National Bank of Russia was not owned or controlled by Ms. Nabiullina for the purposes of sanctions, notwithstanding. So that was obviously not shown to the Court of Appeal at the time when the hearing was taking place. So, but the Foreign Office are obviously quite concerned about this, and they have come out with a statement. And there are 4 points, I think, rising from the statement. What the statement says is, firstly, they say, well, in the case of public entities, we're looking, if we can, to actually provide clear guidance by designating people. In case of private entities, there is no presumption that a private entity owned or incorporated in Russia or with Russian links is owned or controlled by political office. Thirdly, they are going to look at it and hopefully explore the options available to the government in clarifying the position further, so we may get some more guidance. But in the meantime, it is a live issue. As Sir Andrew has said, there has been various issues in the markets. I'm seeing various cases where the point is being taken, and it's going to lead to some interesting arguments absent clarification. Now, that's all I was going to say about the case.
Thank you very much, Sara. Let me next ask Alex to comment on it, the consequence of the decision from the perspective of those you advise on a day-to-day basis.
Yeah, thank you. Thank you, Sara. That was a very interesting and comprehensive summary of it. I mean, the reality is it's a bloody mess because you have a Court of Appeal judgment, a very strong panel, looking at an issue that all of us who operate in this area have had to study on a case-by-case basis. You have very poorly drafted regulations that were drafted really before we were having to face Russia and the specific challenges that have arisen through ownership and control structures in Russia. Leaving aside Putin and that question of the apex economy, the reality is that the way Russian businesses are owned has proved very, very challenging for industry to penetrate. And so when we are looking at the way in which the G7, the UK has approached designations in the Russia context, they've gone after kingpins and king queens, right? If you look at the number of designated entities, it's relatively restricted. Far more thousands of designated persons, and that is quite clever. And I think that was a deliberate strategy by the G7 to say, look, we're going to try and cut the head off the snake. We're going to target those closest to Putin, those who we consider his cronies, and we're going to target them. But we're not going to target Russian industry and the men and women who work in the factories who are innocent or have no say in what is happening in the Ukraine. So it's very clever, on a conceptual level, I get it. But what it means is that it falls to us to sit here and look at the ownership and control, the guidance that comes out. And for each company that crops up on the other side, we go, are they owned by a sanctioned person? Are they controlled by a sanctioned person? And then we look at the pattern of divestment, we look at the trust structures, we look back at the guidance, we look at the legislation forlornly looking for sort of some clue in all of this. And really, we haven't been getting any. And so when I read this judgment, the first thing I thought was, oh gosh, I mean, that's going to put the cat among the pigeons. And of course it did, because everyone's still looking at their sanctions clauses and looking at, you know, if there are different types of clauses out there in the market, and we'll talk about that a bit later, and, you know, reasonableness and those kind of standards. But it definitely puts the cat among the pigeons to an extent. It definitely raises the stakes to an extent while it's there. But I think, you know, one positive that may come from it is that it will force the drafting hand of this regulation and this guidance that they will have to go back to it. And I think, unfortunately, I missed it, but one of my team listened in on the OFSI webinar earlier today, and they were talking about this, and they said, this is a problem. It's a problem that's recognised by OFSI, so that's the Treasury, Department of Business and Trade, so that's they're the guys who deal with the trade licensing sort of stuff, plus the Foreign Office. They recognise it's a problem. They're going to fix it, and you know, so overall, I think you may say this is you know, the best of British in terms of the judiciary providing a check and balance to what is being promulgated. But that doesn't help us now. And it's not going to help us. This guidance is going to come out. If it gets appealed, you're going to end up with a ping pong, and you're going to be looking at non-binding over to judgment versus non-binding guidance, and that will keep going. And that is something that I think we need to get better at as a country if we're going to remain a centre of legal excellence and a attractive forum, because we need the people, the players in the market, and we're going to hear from them in a minute, need to know where they stand. And at the moment, this is pretty unsatisfactory. So that was my 2 cents.
Great, thank you very much, Alex. So can I ask Sandra to give us the Clarksons perspective, please?
Well, I take a very robust approach to this obiter judgment, as Alex well knows. You know, we have a business to run. We have to make decisions on relatively short notice. You know, I take a very simple approach. This is obiter. This, in my view, does not reflect the intention of Parliament around all the legislation around sanctions. If it is correct that basically we're not allowed to deal with any Russian private or state entity, then why do we have all the Russian sanctions legislation that we've got? You know, why do we have the price cap? Because if everything is basically owned or controlled by a designated person, there would be absolutely no point for the rest of these sanctions. Similarly, you know, the regulators are perfectly capable of designating state entities. They have designated a number of state entities in Russia. So, you know, this unfortunately is, I don't know, how do I put this politely?
You don't need.
No. So, you know, that's it. We are not turning away business because some eminent judges made some passing comment. That's basically the compliance department's view, you know, at Clarksons.
I think on that as well, I don't think we've seen any major industry players. Sorry. I don't think we've seen any major industry players not doing business off the back of this with anyone. Some people have been cautious about it. Some people have reviewed the positions, but people continue to enter charter parties with major entities, both state-owned and private, ultimately going up to the top of that apex economy in Russia. Some people are nervous, and some people on the fringe are not doing this business, but principles in the industry, I don't think we've seen a single person step away.
We've also seen the regulators. I mean, they, you know, particularly in the UK, this kind of legislation is relatively new. They did do it very fast. They've had to have a very steep learning curve about, because this legislation, these sanctions impact many different businesses. We've obviously been involved in informing them of, you know, the shipping or the shipbroking issues around it. They've been relatively responsive. You know, they're understaffed. They've been staffing. You know, we have to take this. You know, we can't expect perfection nor precision drafting. But actually, the response that came out of the Foreign Office came pretty quickly and is pretty blunt in terms of this is not their intention and they're going to fix this. And that's also enough for, I think, industry to be able to carry on and take a sensible and robust approach to these obiter comments.
Yeah, I think that's probably quite indicative on the enforcement risk side of this as well. And I think industry has to take a practical approach and in response to quite an absurd position we've been put in.
Yes, thank you. I mean, in a sense, you are, although you say you're being robust, you are making a legal argument, which is that if the wrap-up provision at the end of Regulation 7 swamps everything else, then it makes a lot of the regulation redundant. All right, well, thank you all for those contributions. Let's move on to the second topic, which is, I'm afraid it's still to do with mints, but it's in the context of arbitration. I've certainly heard of arbitrations being stayed or awards being delayed in the wake of mints. I think the LCIA has procured a general license covering its cases, although other bodies may not have done that. Quite a lot of the reasoning in mints, as far as concerns the process of litigation, which is where Sara started, isn't specific to courts as distinct from arbitrations. For example, all the reasoning about continuity with the EU regime. But I wanted to ask Sara how you see the impact on arbitration.
Yes, I can take this quite shortly. I think I agree with Sir Andrew that the broad point, which is that if you're a sanctioned individual, you can bring a claim and you can get a judgment, I'd say applies equally to arbitration. There's a distinction between obtaining your judgment and obtaining your reward, clearly, and enforcement and getting paid. And it seems to me that this is illustrative of quite a practical approach by the courts and also by arbitrators in relation to trying to make a way to make contracts work, notwithstanding the impact of sanctions. And we've seen it in other cases like MUR and RTI, where payments were going to have to be made in dollars, and that was going to cause sanction issues. And therefore the court said, no, you can make payment in euros. Equally, Gravelor, another case, they're prepared to sort of look for workarounds. And then we have the celestial aviation case, which is a quite extreme workaround where they say, well, you can pay cash instead of if you can't pay in US dollars. So I think it's indicative of a practical approach, and that will move over into arbitration. As to, I think that's the first point. I think the second point is that we're going to see this is going to be an issue for certainly unless and until the legislation changes or the Supreme Court reverses it. I'm already seeing people taking points in references about sanctions points in relation to non-designated parties and saying, oh yes, but they're owned and controlled by a designated party, by Putin. You know, see what Lord Justice Flo says. That's a question of facts. I'm a defendant. I want to raise this, and I want you to determine it. So, you know, that's an issue that's going to raise some interesting issues for us as arbitration practitioners and also for arbitrators. The third point, and sort of linking in with Sir Andrew's point about all these arbitrations being stayed, there are still practical difficulties. Payment, of course, if you're a Russian entity trying to get your money out of Russia, also payment of arbitrators. Now, I think it's quite an interesting question. So Andrew mentioned the LCIA general license, but how payment fits in with the other general license for legal fees, which has recently been renewed this week, and whether or not that covers the payment of arbitrators' fees. I think that's a difficult question, which still needs to be resolved. And I'd be very interested to hear from those in the room who've dealt with the problem and how they've sought to resolve it, and whether or not what they think of the general license, or whether or not they're looking at specific licenses in order to get arbitrations going and moving along that involve Russian and sanctioned counterparties. That's all I was going to say about that.
Thank you, Sara. Alex, would you like to add to that?
Just briefly, if I may. I mean, I think generally this judgment, you know, the ratio of the judgment is very helpful insofar as we are having to live alongside sanctions now. You know, we've in the last couple of months, we've had almost unparalleled access to the regulators, particularly in the price cap, which we'll come on to. But the mood music has been, you know, these sanctions not going away. The G7 is doubling down on these sanctions. And so, you know, whereas in the early days, it was just, you know, staying in arbitration or staying a high court proceedings, you know, it was just sort of just trying to control the situation. We're having to move past that. And we will have to resolve all of these cases that are stayed, that have been stayed. And each time we get a general license, each time we get a judgment like this, it improves our understanding of where we can go. And it allows in the commercial sphere for us to be a bit bolder. Now, with this case, I think, and to echo the comments that have come before me, it seems quite clear that the court is taking a very pragmatic approach to this. It's saying, look, guys, don't get hung up about, you know, economic benefit and all of that. Justice must be served and must keep rolling through, and these cases need to be heard. Now, at the end of it, if money needs to be transferred to a designated person, yeah, that's a problem, and that needs to be dealt with through licensing, either specific or general. But it gives, to an extent, renewed confidence for practitioners to get on with this. But I think the frustration is, and Sara and I were talking about this beforehand, it still leaves questions on the table, fundamental questions on the table. And one of them is the position vis-a-vis arbitrators and, you know, their fees. Because if you can't constitute a tribunal, and the arbitrators, you know, feel unable to assist and to progress cases, then actually in practical terms we're no further forward. So that's an area where I hope, you know, we clearly have the regulators' attention at the moment, or this case has the regulators' attention at the moment. I desperately hope that this area of ambiguity, because if, you know, legal professionals in the room can't agree on what exactly is contained in the license, which has criminal consequences if we get it wrong. I mean, these are high stakes to play with. Then something needs to be done better. So that was really my 2 cents on this point.
Thank you very much. Yes.
I mean, something from our side and something from industry on this is, when the Mints judgment came out, everyone was talking about using it in arbitration, trying to terminate charters. And I know it's come up a few times. I'm not aware of it being successful yet, but in terms of anyone being brave enough to actually terminate a charter that's on the water on the basis of Mints, on the basis that the charterer or the owner is owned or controlled by Putin, I don't think I've seen that once so far. Others might have, but we haven't seen that once from our side.
No, well, look, I haven't seen it either, but I do think it goes into a complex matrix of when, and we'll come back to the sanctions clauses and how they operate. But when you are considering your rights under a charter agreement in the round, it's things like this that is just another brick in that wall, really. You know, you can't ignore it for the reasons that we've heard. You can rationalize it. You can put it in your risk profile and say, look, we're going to go on with this. But the reality is, this Court of Appeal judgment will weigh on the judiciary, and actually, OFSI, if you get sanctioned by OFSI, if you get investigated and fined, the final right of recourse is the court, and so there is ambiguity there. So I agree with Angus 100%. This may not be a determinative feature in isolation on a charter on the water, but when you are weighing your rights under that clause, you will have this in the back of your mind, and it will be deployed in that context, has been deployed in that context. So maybe not a gun, you know, but it's there, and something the parties have to consider.
Thank you very much. So we're going to doing a slightly different order from what you see on the slide. We're going to go next to the G7 price cap, evidence of a maturing sanctions landscape. And in fact, I'm going to start by asking Alex, in what sense do you think we are seeing a more mature approach to sanctions?
Yes, thank you. So I think everyone in this room is broadly familiar with the price cap. By way of very brief summary, you know, the EU and the UK, or the G7 as a whole, has moved to ban the import of Russian oil and products onto our shores, what we now have from 5th of December in respect of crude and 5th of February in respect of product of this year is quite a complex bit of political and legal creation, whereby you can transfer Russian oil and Russian product from Russia to third countries via STS transfer, ship-to-ship transfer, if need be, and that is permitted activity. And so your G7 ship owner can carry this stuff, your ship brokers can broker it, and your insurers can cover that vessel and indeed the cargo on board, but it has to be compliant with the price cap. So that is what we're talking about. That's sort of setting the scene. And evidence of a maturing sanctions landscape. Yeah, I think it is for a number of different reasons. I think the first reason is that you know, as we lived through 2022 and watched what was happening on our screens in the Ukraine, the regulator reaction and probably a reflection of public sentiment as well was to start shutting down touch points with Russia. You know, we were just told no, whether it was on the asset freeze side, which we've been talking about, or on trade, you know, things like coal, steel, whatever. You know, you saw these barriers coming down. By the end of last year, I'd say by Q3 of last year, there was a realization on the part of the regulators that this was actually having very profound negative consequences for the third world, and indeed, you know, for the global economy, because there was a huge amount of reliance on Russian fertilizers and Russian energy. And so that's where the price cap came from. So you saw the G7 plus G7 allies. It's not just as G7, obviously, there's a number of the price cap coalition sat down and they said, okay, oil is a big money spinner for Russia. We've got to tackle it. You know, the folks at home don't like the fact that, you know, we're just dealing with Russian oil, that something has to be done. But what we're going to do is something that's not a complete hard no. It's going to be a cap and controls in place. And so I think that is that's the first reason why it's maturing landscape. It's living alongside sanctions, living alongside this kind of paradigm that we're in now. So that's the first. And then the second reason why I think it's evidence of a maturing landscape is because for the first time really, and the shipping community has lived through a lot with Venezuela and Iran on the US side, it was the first time we'd really seen the regulators recognize that there are different players. It's not just shipping and commodities. Different players have different levels of knowledge and should come to different standards. And so you had this tier-based system, which we're all familiar with, I think, in the audience, but recognizes that if you're tier one, if you're the trader, if you're looking the Russians in the eye and buying this oil or product from them, then you need to know that you're buying this stuff below the cap set by the G7. By the time you get to tier two actors, sometimes you have it, sometimes you don't. There's a recognition of that in the guidance. And as a consequence, you know, a lower level of due diligence required. Then you have tier three, and this is where you know the sanctions enforcement landscape sort of inverted, because in the past it had always been the ship owners, the Western ship owners and the insurers behind that bore the brunt of regulatory investigations and enforcement action. And here what we had was the G7 saying, tier three actors, you know, Johnny, Sally, ship owner, you don't normally know the value of the cargo that's, you know, that's in your holds. You don't have access to that information, so we're gonna hold you to a lower standard. And the insurers behind, you know even less. I mean, so, you know, until a couple of years ago, you didn't even know where the boat was. You know, it was an annual policy, and you could check, obviously, go on marine traffic, but you wouldn't, as a matter of course, know where the boat was unless there was a casualty, in which case you would know exactly what had gone on. And so, you know, you have this attestation model which basically creates or almost creates a fiction. So you have what's happening in real life, but then you have what's happening on the paper trail. And the entitlement is that you are allowed to rely on the paper trail. Now, the twist in the tail of this, and we're going to come back to this in lots of different ways, is that you're allowed to rely on your attestation as long as it's reasonable for you to do so. And as we move in, as we did 3 months ago, we moved into the territory where the price cap was being routinely breached or exceeded across the board on crude and products. We then moved into this real tension between the paper fiction of the attestation, this cargo is below the price cap, and the reality actually that in many cases there was cargo, that type of cargo being traded above the cap. So that's sort of the scene setting on it. I think one third area of maturity before I hand over to colleagues is that we have had a considerable amount of engagement by the regulator, unprecedented, I would say, actually. We've had, I think, most of us in this room will have had an opportunity to meet with OFAC or OFSI or DG FISMA representatives, had one-to-one sessions with them, had a chance to feed into the guidance that's coming out. And there has been a feedback loop, and certainly, Reed Smith, we've contributed to guidance that has been published by OFAC and OFSI. So that there's, there is that discourse, which I think is crucial when you have something as complex as the price cap. And that is not something we've seen anywhere else in the sanctions, certainly on the UK side, whether it be Russia or anywhere else. We just haven't had the opportunity to really sort of not petition, but educate the regulator. And so they're my three areas of maturity, if you will.
Great, thank you very much indeed. Can I ask Angus how Clarksons manage these price cap risks?
Yeah, certainly. I think Alex probably covered most on the maturity side, as from the regulators and the legislation. I think what we've seen as well is we've seen a huge maturity from industry players, and the price cap and these other Russian regulations that have come out have forced everyone to set up compliance departments, to have legal teams, to go and seek external advice from sanctions lawyers with specific shipping understanding as well. So I think there's been the industry has matured greatly over the last sort of year and a half, specifically with the price cap. What it means for us as a tier 2 actor or tier 3 actor is that we have to obtain the price cap information, or we have to obtain the attestation. We have to do our due diligence to ascertain who is providing this information to us. Do we have any reason to question that the attestation might be false, or the actual price cap information that we are provided might be false? So you might have fraudulent attestations, you might have fraudulent sale contracts, etc., that might be provided. So we look at that and we go, okay, we've done our due diligence, we know who we're dealing with, it's a reputable party, we've got the attestation. We then look at where's the cargo coming from, where's it going to, who's the supplier, all the rest of the usual KYC sanctions requirements that you'd have to look at. The real challenge that Alex alluded to is, can you have a reasonable belief that the attestation is correct, or that the price information is correct, now that I think bar one of the major premium to crude products is trading on the open market above the cap. The general sentiment and guidance that we've seen from both OFSI, OFAC, DG FISMA at various industry events and engagement is that the fact that it's trading above the price cap is not in itself a red flag. It means that you have to do more due diligence. You have to really look at who you're doing business with, and that you can reasonably rely on what they're telling you. This whole landscape is becoming more difficult because it's putting more and more of a judgment on the individual market players to look at someone else that they're dealing with and going, can I reasonably rely on what you're providing? I think it's taken it much more into a territory where it's a little bit more gray. It's It's not a, you can do this or you can't do this. It's, can you reasonably rely on it? And if you can, then you're able to proceed. So the way we look at it is, if we've done our KYC on the individuals that we're dealing with, we know who we're dealing with, we've got no reasonable cause to suspect that they might be telling us is false. If they've fraudulently tried telling us something in the past and we know that the cargo is coming from Russia, but it's not, we have a reason to question their bona fides and we won't rely on their attestations. But if it's someone we've dealt with for 20 years, major trader in the market, major charter in the market, and we know who they are, we have no reasonable cause to suspect that they're lying to us, they haven't before, then we will continue to do business off the back of that. And that's been largely, I think, supported by OFAC, DG FISMA, OFSI, and a lot of the comments they've made to the market. But I think clarity at this point from the regulators, especially around this, is key because it puts industry in a really difficult position.
I guess if I may, it's just I think it is challenging, as you say, and I think it's getting more challenging because actually you move away from the pure attestation model to the reasonableness of relying on it, and that takes you squarely back into due diligence sort of territory, and that, for many reasons, is a complicated area, particularly where you have in the last 18 months had a flight of industry to jurisdictions that is very hard for us to penetrate, right? And this was something that was recognized at industry events by the regulators. You know, they know, you know, that, for example, I'm not naming one jurisdiction in particular, but just for example, Dubai, they know that there has been a flight of companies to Dubai, and they know, because we've told them, that it's actually blooming difficult to get information out of that jurisdiction as to beneficial ownership. And so, you know, you end up with a square that's, or a circle that's, you know, square that's increasingly hard to circle because the regulator says to take care. You know, you look at the recent guidance that's come out of the EU on circumvention, you know, about trusted counterparts and stuff. But the reality is, and I think this was something that was recognized by the regulators recently, is that there has been a flight of people, you know, traditional Western players to the Middle East. And if you are to continue to trade in Russian oil, if you continue to transport it, that necessarily involves more and more now doing business at one level with those entities. So you know, guidance is helpful, and we always, as industry, every time we see the regulator, we grab them and we say, give us more guidance. But in some cases, with the price cap, almost too much guidance is a bad thing because then it increases the burden back on us to start looking behind the paper construct that they've created for us. So
I think a lot of the guidance, while it's been very helpful, a lot of the guidance, not just on the price cap, has actually made the position more unclear than the actual legislation itself. So I completely agree with that. I mean, I think what we've seen as well since it's been trading, the open market's been trading above the price cap, is I think we've seen a marked drop in the number of entities that are chartering vessels with the Western fleet, and we'll get on to the sort of the dark fleet in a minute, but we've seen a marked drop in the last few months. I mean, I'd say we're probably seeing a third of what we were seeing 3-4 months ago. So I think, is it working? Maybe. Is it just flowing to other entities that won't deal with Western players that have a reputation for having a sanctions program, for reviewing the documents, and for, frankly, sanity checking what they're getting? Maybe that's why we're seeing less as well. I don't know.
Thank you very much. So we've neatly moved towards our next topic in our order anyway, which is due diligence. So I think I'll go first to Sandra just to talk about some of the nitty-gritty about how one deals with it.
So first things first, the Price Cap Coalition recently issued an advisory on price cap guidance around how to cope with reliance on attestations and the kind of due diligence and risks that you need to be aware of. And they specifically stated, I'm going to quote here, due diligence is especially important where market assessments indicate that Russian oil prices exceed the price cap and coalition services are being used or sought. So everyone needs to do their due diligence if they wish, if they're big UK, US, EU, they want to provide services or vessels for the movement of Russian oil to third countries. So what are we trying to achieve, and what does good due diligence look like? Again, I have to take a fairly pragmatic approach, and the impression that I've got from the regulators when interacting with them is you've got to do your best. You can't do more than that. And so I think my approach to this is we make sure that we look at everything that we can possibly look at in line with the various guidances that have been issued to the maritime industry since 2020 on managing sanctions risk generally, as well as the more recent price cap guidance. So what we're trying to do is we're trying to make sure that no party, so I'm looking at it from the shipbroker's perspective, we actually engage with, whether they're our clients or not, we are facilitating a transaction where we're putting together or participating in putting together owners and charterers, plus there's a vessel involved. So the first thing that we have to go and do is check that the owners and charterers, and that's registered as well as disponent, as well as the vessel itself, whether they're on a sanctions list. So that's the first check that we do. We then need to try and figure out the ownership and the ultimate beneficial ownership of all of those parties to make sure that they're not one of the sanctioned individuals or owned by a sanctioned entity. So that's another thing that we have to look at, which involves relatively detailed due diligence. We then need to check that even if the charterer is registered in Cyprus or Panama or the UAE, that it's not being run by Russians who may be domiciled in Russia. So that then, on occasion, we've actually sent personnel down to have a look at offices in, say, the UAE or in Cyprus to see, is it a real office? Are there people there? We look at things like Facebook and LinkedIn to see if these Russian individuals are posting, selfies of themselves in Dubai or not. So it goes down to an incredibly granular investigative level. So those are the areas, and then we obviously have to look at the origin of cargo as well. So those are the areas that's why we're doing the due diligence. Who are the beneficial owners? It is sort of key. Do the parties actually exist to the transaction? Where are they registered and where are they domiciled? So what does that mean from a practical perspective at Clarksons? How do we do this due diligence? Because at the end of the day, this is what this debate is all about, is, have you done your due diligence? Because doing due diligence ultimately can result in your defense in the event that you make a mistake, or you get deceived, because of course there is growing levels of deception around. So we use third-party tools like Orbis and WorldCheck. Orbis in particular is relatively good at showing ownership structures. We look at our own systems, our own, if I focus on the third-party sort of databases, we also use Aquasis. We look at the Baltic Exchange, whether there's any published information about, users. We have our own Clarksons Shipping Intelligence Network. We look at registries. So obviously, in the DMCC and, where companies are registered and therefore directors and owners and things, wherever we can get that information, basically. We actually find LinkedIn and Facebook and Google, just a plain old Google search is very useful for seeing ownership. People tend to make mistakes on LinkedIn and Facebook, and everybody wants to advertise where they worked and where they're working. And they often put, where they're living on there as well. So that gives you a heads up whether they're actually resident in Iran or Russia. We scan all the trade press, and we look at vessels and shipping entities and any references in key media, whether it's Tradewinds or the FT or the New York Times, UANI, United Against Nuclear Iran. So there's a whole database there that we actually are now using ChatGPT to go through all of these reports and extract key data for us, which then our sanctions team review. We then look at trading patterns when if a red flag comes up, we look at the trading behaviors of the vessels. So that's pretty key in all the Off-Sea OFAC guidance is AIS deactivation, flag hopping, name changing, obscure corporate ownership structures. So we look at all of that as well if we see something that we're not comfortable with. And in the absence of being able to secure any data, we'll actually approach the party themselves and say, you know, who are you, who owns you, who are your directors? And these are in fact on multiple occasions being these illicit shipping behaviors. All of these red flags have been clearly identified by particularly OFAC, also Off-Sea. Then more recently, we've had this price cap coalition advisory that came out that talks about increased risk, in the maritime trade. And this kind of segues quite nicely onto the shadow fleet or the shadow trade. But in all of this, they keep repeating false registrations, flags states changing. They focus on P&I cover and obscure P&I cover for the vessels, disabling and manipulation of AIS, class, this migration into less blue chip classification societies. They're also now talking about inflated shipping and insurance costs. So if you're selling CIF, you'll show your cost of the product as being below the price cap, but you try and claw that, the reduced price that you've put into the product into upping the IF part of the CIF price, and you're heaping it into insurance and freight costs. So, this is not information that we have access to because we're not tier one and seeing the actual sale price, but tier one parties should be able to pick up whether there are insurance and freight inflated costs there. So obviously the regulators have picked up on that level of fraud. We're also seeing increasingly false, not increasingly, but we have seen occasions of false certificates of origin, which is helpfully obscured by multiple STSs. So there is more and more subterfuge going on, more and more complex and opaque structures. We're also seeing, as Alex has referred to, a migration over to the UAE and China as well, Hong Kong as SPV registration locations, which historically we've not seen. There's a big change in behaviors. You have to be aware of it. You have to do your due diligence. And at a certain point, you do as much as you can. You document it. You make a reasoned assessment of risk, and you either proceed or choose not to proceed. And that, again, is the rather practical approach that we take at Clarksons.
Thank you. Just a question arising from that. It sounds like a lot of work. Are you having to do it on a transaction by transaction basis, or do you find you're able to build up over time a kind of database about known entities and vessels?
So we have to onboard each party. So you have to do it on a party basis. So that is your KYC element of it. And you also have to know your transaction basis. We now have a team of 9, or we will have a team of 9 when they're all fully operational. So we've gone from 0 to 9 over a 5-year period, really. KYC now has become really front and center of managing risk, both AML risk, money laundering risk, sanctions and sanctions risk. So it's no longer a nice to have in our industry. It is unfortunately part of the cost of doing business today.
Thank you. Any other thoughts on due diligence before we go on to the dark fleet? No, all right. Well, we'll stay with you, Sandra, then. Can I ask you, how do you define the dark fleet and what do you see as its implications?
Well, there's a lot of excitement and a lot of media interest in the dark fleet, and it's all very sexy and exciting, and I think it gets very, very confused And you often read in the not necessarily trade press, but certainly in very reputable press, whether it's New York Times or Financial Times or the Times, etc., that talks about the dark fleet because it's doing Russian business, having missed the whole point of the price cap and the fact that European and US and UK businesses can handle Russian oil in certain circumstances. So a lot of that information is wrong, or the presentation of it is wrong. We at Clarksons have tried to get our head around what we think the dark fleet is, and we've landed on a fleet of vessels whose ownership is obscure. And by obscure, we also add, that includes complex ownership structures, unusual ownership structures, or regularly changing ownership structures and names, migration into the dodgier class and the flag registries. That all for us adds up to suspicious ownership. Plus we couple that with a potentially illicit behavior pattern, which probably falls into the name hopping and flag hopping and ownership hopping, but also the AIS deactivation and spoofing. So just because we can't identify particularly comfortably the true UBO of a vessel doesn't mean we put it into the dark fleet, because most of the time we are told who the UBOs are. And some of the structures we see are relatively newly incorporated UAE entities that have an Indian owner. And on the face of that, we don't necessarily suspect that. But if we combine it with one or more of these red flags, which have been amply described by the regulators, then we do classify that vessel as a dark fleet vessel. And in fact, interestingly enough, this latest price cap coalition guidance talks about the shadow trade and it involving actors and cargo affiliated with countries and persons subject to sanctions or associated with illicit activity, characterized by irregular and often high-risk shipping practices, older vessels registered with flag states that fail to meet international obligations, falsified registrations, unproven P&I, complex corporate arrangements, disabling or manipulation of AIS systems, inflated shipping and ancillary costs. So again, the dark fleet feeds into all that due diligence that you're supposed to do. And again, we come to the point where we have to do our due diligence and take a view on whether this vessel is ultimately Russian-owned or Iranian-owned. But then we will also look on the transaction side of it. And if it is lifting cargo from India or from China and going to India or vice versa, and it's not, in our view, the UBO isn't Russian and or Iranian, we would take do business with that because there are no risks around the particular transaction. So we have to combine our knowledge of the parties and the due diligence we do on the parties, as well as the due diligence around the transaction itself.
Thanks very much. Angus, can I ask you, how do you see the impact of the dark fleet phenomenon on the market generally and some of the practical effects of that?
Yeah, I think as a starting point, we've obviously seen a huge shift of tonnage away. We're seeing more vessels being bought by opaque structures, in particular out of the UAE, India, and others. And we're seeing the world fleet shrink for G7++ participants. And tied in with that, going back to the due diligence point before, another one of those key red flags that you see in the industry is if someone's going to purchase a vessel, an unknown, a new UAE entity that's just popped up that's going to purchase a vessel at say 20% above market, that is automatically a red flag that really ought to be investigated. And that's when due diligence comes in more and more. I think turning to the price cap as well, we're seeing more and more of this business being driven away from the G7 participants in the G7 market. You're seeing more insurance coverage moving to outside of the IIG and to lesser known players. You're seeing innocent charterers that have done, or charterers or ship owners having done everything that they can, looking at the UBO of the vessel and or an owner looking at the cargo that's on board. And you've got real challenges around if you're made aware of a vessel, if you're made aware of the true origin of a cargo when a vessel's mid-voyage on the water, it's leading to really difficult scenarios when insurance cover is pulled because of the sanctions and the sanctions clauses that they have, where you've got innocent parties that are fundamentally subject to fraud. And we've seen time and time again where very reputable industry players that are doing everything they can, say, for example, on the ship owning side, considering doing an STS without cover. I mean, it's leading to real environmental and practical challenges in the industry. And I really hope that the industry doesn't go too far on this and that people instantly pull cover, people become that there's maybe an overreaction, for lack of a better phrase, to these restrictions, because it's not sending the industry into a good position. And it's really pushing legitimate players down that road. I think additionally as well, we're seeing the G7++ participants shrinking. It's leading to less oversight and control from the regulators. It's leading to less control and, frankly, sovereignty around energy security. If you lose control of the fleet and you lose control of that flow of resources and you can't control it, you can't enforce sanctions on it. And for UK and EU not taking things, not applying the extraterritorial approach that the US does, you're actually losing oversight and control of this. So I do struggle slightly with the intended outcome of the legislation. And they state, I mean, in the price cap guidance, they state, I mean, right at the top, the coalition is committed to encouraging responsible maritime trade in crude oil and petroleum products within a reputable, safe, and secure market. And driving people from having legitimate proper cover and forcing insurers effectively under the legislation, which I think is frankly rushed and poorly drafted, it's not leading to a good outcome for the industry. And I think as we've seen on numerous occasions, it's led to disastrous outcomes with spills, etc. So I think that's a real challenge that needs to be addressed.
Thank you very much. Looking at the clock, we'd better go on to our last topic, which is sanctions clauses. There are quite a few aspects to this, I think. There's the question of how effective they are generally, and then there are particular situations like the use of Russian oil price cap clauses, chain contracts, and some recent cases on letters of credit. Can I ask Sara first of all, just to give your view on the efficacy in general of a well-drafted sanctions clause?
Thank you. The question is, are they a panacea? And I would say no, they're not a panacea, but they are, to coin a phrase, evidence of the ever-maturing landscape of sanctions and how we deal with them. We've always had these sort of clauses. We've always had force majeure clauses, for example, and we still have force majeure clauses, and force majeure clauses crop up in sanctions. The MUR and the RTI case I mentioned earlier, the Court of Appeal case about how you could get round the fact you couldn't pay freight in US dollars. That's a force majeure case. That's a case where the judges said, well, the clause said if you couldn't rely on it if you could get round it, the problem by the exercise of reasonable endeavours. Held you could do that by converting the payment into euros and dealing with the currency risk. So we had force majeure cases, but these aren't appropriate really to deal with all the complexities that are raised by sanction clauses. So increasingly, we're seeing sanctions clauses. They are becoming ever more lawyered, ever more specific. We have the BIMCO suite of sanction clauses. We have the very recent price cap clause. They are being developed for very specific situations, becoming ever more complicated, ever more specific. I think largely speaking, they are a good thing. They are effective, but at the end of the day, they depend upon the words used and the construction of them and whether or not they are specifically enough to cover the situations that people find themselves in. I thought I'd just highlight, as time is short, 3 particular aspects which I think create issues at the moment. The first one goes back to the Mints judgment. Often the trigger for sanctions clauses is that there is a sanctioned individual. Now that doesn't, and a sanctioned individual is generally thought to be a person on a list somewhere. Now, how does that dovetail in with the more wider definitions of owned and controlled, which we see in the UK and also in the EU sanctions legislation? The US takes, as I'm sure you know, a different approach. So that's one issue. The second issue is construction of them. Do they fit the particular facts that somebody finds? Should they be construed expansively or should they be construed strictly? And if they are, what do you have to demonstrate in order for the clause to be effective? Now, we've got a recent example of that in a Singapore Court of Appeal case called Cuvera Resources and JP Morgan, which was, the judgment was given about a month ago. It's an LC case, and letters of credit raise particularly interesting issues in the interrelationship with sanction clauses, because as I'm sure a letter of credit is an autonomous contract. It's not meant to be, it's meant to be a very quick, easy way to get paid, very, very limited defenses, don't look at the merits. Sanctions clauses create an additional layer of difficulty. So, but in this case, this was JP Morgan, we're soughting to resist payment on the basis that their internal due diligence, their internal watch list had triggered a red flag on this particular transaction on the basis of Syrian sanctions, actually not Iran or Russia, held by the Singapore court at first instance that they could rely on their internal list, they could rely on their own subjective analysis. This was overturned by the Court of Appeal. The Court of Appeal, and this may be symptomatic, I say, of an approach more generally to letters of credit, which is letters of credit are meant to be things that get paid, not things that you can put up a whole raft of defences to payment. They held you have to construe it strictly, and whether or not the event, the sanctioned event has happened, has to be construed objectively. So depends upon, in this case, somebody being sanctioned depended upon the OFAC status. The fact that OFAC had given some guidance that suggested they might be thinking about sanctioning this particular, wasn't sufficient. JP Morgan's internal list wasn't sufficient. So a very strict approach to sanctions. Now, again, that raises different issues with clauses that extend not only to sanctioned individuals, but where there is a risk of sanctions. You see this quite often that counterparties can terminate if there's. Now, how do you construe that? How real does the risk have to be? Again, how do you prove your risk? Those are all questions which are difficult and interesting, but lead to uncertainties for the market, I would suggest. And then finally, as there are ever increasing numbers of sanctions clauses and ever increasing attempts to try and tail them to particular situations, you can get yourself into difficulties with mismatches between different contracts that form part of the same transaction. If you take, for example, MOAs for the sale of ships, those now normally contain a sanctions clause. Allied to that, you may have guarantees. Have they got sanctions clauses? Escrow agreements, have they got sanctions clauses? And if so, do they all tally together? Because if not, you can find yourself stuck between a rock and a hard place. So I think they're generally a useful and a developing tool, but I wouldn't say they're a panacea for all woes. Thank you.
Alex, how do you go about drafting sanctions clauses or advising clients about them?
Yeah, so I was at the start of the year, I was on the BIMCO drafting committee for the price cap clause, and you end up, it's very difficult because obviously the more specific you make the clause, then the more sand trickles through the fingers, as it were. So we on that particular committee for that particular clause, it's actually quite straightforward in a way because we had clear guidance from the regulator. We had the BIMCO suite of clauses anyway, and so what was important there was to build a clause that dovetailed or sat neatly within the other sanctions clauses, more general sanctions clauses, and perhaps more general lawful trading order clauses in the Charter Party. And so I hope what the committee achieved for that clause was a relatively straightforward document that was easy to understand. There were a couple of key points that weighed on us. One was to really embrace the attestation model. And very early on, we were clear that we thought it was appropriate to have an attestation, which is an annex to the charter, for each time cargo was lifted. So we were not in favour, even where you have a tier 3 actor, of having just a more general sort of general clause. We thought it would be a useful paper trail exercise to have that bit of paper each time. So when the enforcement and the investigation starts, which it has now, it's much, it's a practical point. When the regulator comes knocking, you're able to give a bit of paper. It's a bit of paper they expect. And indeed, we just regurgitated the standard clause that they gave to us in the guidance, and you give that back and you try and short circuit, trying to explain to a regulator, how 7 different recaps and incorporated clauses and all of that sort of stuff, trying to explain to a representative at the Treasury how that all works and trying to, sift through a 90-page document. So that was one thing we wanted to do, was to make it clear, make it short, make it what we thought the regulator wanted to see. The other thing that we really wanted to try and address with the clause, and when we drafted the clause, we asked for input and feedback from OFAC, OFSI, DG FISMA, was on this scenario that doubtless you'll have heard a lot about, and it's one that vexes sanctions lawyers every 3-4 months. The scenario where the cargo on board the vessel, while it is still on the water, turns out to be tainted by sanctions, the industry, and particularly the IAG and the P&I side of things, has learned through bitter experience through the Iran program and the Venezuela program. You on the one hand, you have your member who in many cases has done nothing wrong. They've been duped. Yet you are forced to sit there and you can't do anything because you're exposed directly to your own sanctions if you deal what you know to be sanctioned cargo now, because the regulators told you. And so when we were developing this clause, we really wanted to build on what BIMCO has done in the past and try and build a mechanism which allows for an orderly discharge of the cargo ashore. And actually that the process has been gratifying to an extent, because you actually now have OFAC licenses and you have OFSI and FISMA guidance that allows people the wriggle room and flexibility to get cargoes off, coupled with, I think now, a much more responsive regulator when it comes to the next voyage after, and getting specific or special licenses where one is needed. So going back to the question, are sanction clauses a panacea? They're clearly not, and they've often where they come undone is in that live fire situation on the water. One is where the cargo is tainted. That's what I've just talked about. The other ties back into this grey fleet, dark fleet, bright fleet. What is it when a vessel's nominated as your daughter STS partner? do you have the flexibility to reject that, even though everything about it is screaming to you, this is a terrible idea. If I had discretion about this, I definitely wouldn't do this, but I'm locked into my clause, even my standard BIMCO clause, and it's telling me, is this a sanctioned activity? Is this a sanctioned counterparty? I don't know. And that is somewhere where I think the promulgation of guidance, and there's been a lot of guidance this year and last year as well. I think that's really helpful in this sense, because it allows the innocent party or the less, the potentially wronged party, it allows a checklist to go down. And so it puts some science behind it, as opposed to in the past. I mean, we know what a dubious ship looks like when you use dark fleet ship, but we know what a dubious ship looks like. We know what a dubious counterparty looks like, but our instincts, our guts, from doing this for how many years, that is hard to then articulate in a legal reasoned reason for rejecting a vessel. And so when Sandra's helpfully gone through some of this stuff, when you actually have, a reference to, is it non-IG insurance cover? Is it correctly capitalized? That's now it's something we can tick that. Excellent. Okay, it's not that. Right. Next thing, opaque ownership structure. Well, all shipping companies have somewhat opaque shipping ownership structures, but you can take that a real super duper sort of doozy. Then yeah, that's another box you can tick. And so it's helpful. It's helpful. It's a lot of work for us, because we have to stay on top of the guidance, because we take that and we use it as a weapon. We deploy it when we need to, but it's there now, and it wasn't there 18 months ago. And that is as a defense as well. Yeah. And so, it's in some sense it's getting harder, in other sense it's getting easier.
Right, thank you. Let me just finally ask Angus or Sandra whether you've seen a sort of evolution in these clauses in the market.
Yeah, I think we have. And I think we've seen these clauses adapting to meet the needs in the market as the sanctions change. I mean, I think, as Sara alluded to earlier, historically the sanctions clauses were driven by charterers or traders, and they were very much in the shipping space focused around making sure that the owner or anyone in the ownership chain or managers, commercial managers, etc., are not owned or controlled by someone who is sanctioned. We've seen that, I think, particularly with the Russian sanctions, flipped on its head. We've seen owners, especially around price cap, driving change in the sanctions clauses and enforcing these clauses. What happens when a sanctioned cargo is on board? How do you get it off? What's the process? What's the mechanism? And making sure that no one during the space of the charter or the transaction does anything that causes any of the other parties to breach sanctions. And importantly, looking at not just them, but any party that is connected to the transaction. A real challenge around that is you've got to get these clauses agreed in the market. And the BIMCO clause, I think, walks the line reasonably well, but you will have conflicts there. You might have a UK owner and an EU charterer, for instance. An EU charterer will say, well, I'm not going to warrant that I agree with UK sanctions law because I'm not bound by it. And frankly, it's not part of our due diligence program to look for it. So we're seeing more and more conflict when it comes to negotiations around the terms of a sanctions clause. And on the surface, it seems, okay, well, I'll agree that and warrant that I'll comply with US, UK, EU, any applicable sanctions laws. But you do see industry players, and rightfully so, saying, actually, I won't. And it's a real challenge when our clients are butting heads on that. So.
Right. Thank you very much. So we'll now move to questions. And I think Nick is going to see whether we have questions from Zoom participants as well. But are there any, to kick off, any questions from those in the room? Or observations? No. All right. Well, while you're thinking about that, anything from Zoom?
Luckily, yes.
Yes.
Yes. First question that came in was this, probably one for Sandra, I imagine, but most of the third-party sanctions checks websites don't provide info on UBOs, you alluded to that, and companies are not forthcoming with providing this information. How do you do your due diligence on that?
Orbis actually does cover a lot of UBOs. We rely quite heavily on Orbis.
I think on that as well, reaching out to your clients, reaching out to people in the industry. I mean, it is very comforting when someone turns around within a number of hours and says, these are the directors, these are the shareholders, this is the ultimate beneficial owner, this is the structure. Transparency, and if people are willing to be transparent, that is quite frankly a green flag, as opposed to a red flag if people turn around and they're saying, no, we're not providing this, we're not providing X, Y, and Z, then that becomes a further red flag as well. So
yes, I mean, if we have a scenario where we're unable to identify the UBO and we ask a party to a transaction and they refuse point blank, then I'm afraid that party doesn't pass KYC.
Anyone in the room at all brave enough? Well, there's one on the screen. Andrew, shall I read that one
Yes,
out? Do you think the dark fleet is causing freight rates in the remaining legitimate fleet to go up, or is it the case that the supply of goods is split as well as the supply of ships? So effectively, it is price neutral. That might be a commercial question, which sounds like it is, as opposed to a legal one. Does anyone feel brave enough to answer it?
Well, I think we have seen freight rates go up. So I think the facts follow, it speaks for itself, really. I'm not in the commercial, but what I imagine will happen is there will be a bifurcation in due course that is fairly complete, and there will be two different markets. And perhaps then each market will determine its own freight rates. But from a simplistic supply and demand perspective, what were the stats we were looking at, Angus, on Vs, for example? What percentage of Vs did we think might be in the dark fleet? It was quite significant.
I mean, I think some of the stats we were looking at suggested about 10%.
Yeah.
If you include, I would say, the growing Iranian shadow fleet.
So in that case, if you remove 10% of your supply, it will have a knock-on effect. But there are also other factors involved, such as the paucity of new build vessels on the market and changing regulations in other areas that make vessels no longer, basically it's an aging fleet. But what we are seeing is that aging fleet is migrating over to the shadow fleet, really.
Yeah, I mean,
because they're not usable, particularly in the West, and owners have found a nice market to sell their aging fleet into.
Yeah, I mean, I think the recent designation of the Golden Bosphorus, the EASA vessel, was an example of this. I think we saw and Alex can probably speak to this as well. I think we saw a flurry of charterers looking for vessels from extremely reputable players that had not been doing certain business, and they were paying a premium for that. So if you want to charter a vessel from someone that is not doing any Russian business, legitimate Russian business, and you want to take a vessel that's not trading Venezuela or other regimes or other jurisdictions, you will ultimately pay a premium for that. Mm-hmm. And we are seeing that in the market.
Yeah, there's one more, and then we'll probably be up to time. But sanctions clauses in shipbuilding contracts with Chinese yards, are they effective if you have to agree that Chinese sanctions will also be taken into consideration in addition to the G7 UN sanctions regime? Alex, your finger is on the button.
Well, something have a go. Look, this is a question that comes up quite a lot at the moment. Obviously, China is a significant shipbuilding nation. There has been unease I would say, watching the tensions rise between China, and the US in relation to Taiwan. The Chinese, just taking a step back, the Chinese have their own sanctions program, nascent. You see it from time to time when they sanction some barrister chambers, politicians, but it's really sort of, these are high-level political statements. Obviously, the US and China that's a bit more serious, and that's descending into the technology space, and that has been ramping up. But the Chinese also have an anti-boycott law, which has not yet been, they haven't sought to use it, but it's there and it's already written down. And so I think where the unease comes here is if there continues to be escalated tensions between China and the US in respect of Taiwan, and you have these clauses, do you end up very quickly being in a situation that we had with Iran, where you might recall that the US obviously has secondary sanctions, widespread secondary sanctions in respect of Iran. We all have to abide by them. But we also have the anti-boycott laws in the UK and the EU side, which has led to this heard it once, heard it a million times, rock in a hard place. What do? You're not going to breach US secondary sanctions because OFAC will come down on you like a ton of bricks. But at the same time, it's criminal law in the UK, serious consequences if you don't. So I think that is really where the nervousness lies, where you have Chinese sanctions law mixed in with G7 sanctions law, because you have two jurisdictions that in certain areas may be fundamentally sort of against one another. There's not a huge amount you can do with that. I mean, if you have a Chinese counterparty, on a basic level, they will have to abide by their own laws anyway. Obviously, the sanctions clause raises the stakes, go further than that. But I don't think it actively undermines the G7 sanctions. It's possible in 90% of trade to comply with both Chinese and G7 sanctions. So it's really that looking forward. That's where it gets really nasty and quite problematic, I think.
Well, thank you very much.
Yeah, I think that's right. I mean, what arbitrators or courts will do is they'll try and read them both together. So it's only, say, in the situation like you get with Iran at the moment, where there is a mixed match between Iranian US sanctions and UK and EU sanctions because of the fact that the US left the GCPO, so you can get stuck between the rock and the hard place. But if you can read them consistently, that's what the courts are going to try and do. And the fact that the Chinese may have boycotted, for example, a particular barristers' chambers, may be perfectly consistent with the EU G7 sanctions, but it's what's going to happen in the future. And then, you can be in situations where you're just going to be in sort of double jeopardy. This sanction is cut out by this sanction. And but at the end of the day, as Alex said, if you're dealing with Chinese counterparties and you're going to want to enforce in China, you're going to have to decide which way your bread is buttered, I suppose.
Right. On that note, thank you very much. I'm sure more questions will be welcome over drinks. I think Nick's going to do some thanks, but can I first of all thank Reed Smith very much for your generous hospitality and also for playing such a leading role in organising and indeed participating in this event. Yes.
Good evening, everybody. My name is George Eddings, if you don't know me. One of the hats I wear is I'm a director of the LSLC, so it's in that capacity that I'm standing here now. What I have to do is both difficult and easy. It's difficult because you guys want to go and have a drink and you don't really want to listen to me and to push this out any further. But the easy job is that all I have to do is to say thank you. I have two sets of thanks to give. One is to the panel and one is to Reed Smith. To the panel, we all know the amount of work that it goes into putting together these events and the thoroughness that you've covered these topics and the thought you have put into it this evening is evident. It really is crystal clear. So thank you for the hard work you've put in. But particularly, if you look at the banner behind Sandra, It reminds us that we're a business forum. We're not a legal talking shop. We're a business forum. And what you have done today, I think, has been a paradigm presentation. I really mean that. You've taken the legal side, but it's the practical that you've put to us. So to paraphrase one of you today, you guys have done a bloody good job. So thank you. That's the first thing. The second thing, well, we've seen the COVID inquiry. I think this week, I don't think we've quite gone as bad as that. And the second thanks is go to Reed Smith, obviously, to their hospitality and to hosting us. We don't take this for granted. But I also wanted to thank you for being a very committed council member of the LSLC. You do the hard yards, you come along to the evening meetings and discuss what topics we're going to put. So I wanted to thank you and indeed all the other council members, a number of whom are here this evening, for all the work you do. So that's it from me. If you'll put your hands together and thank everyone for an excellent evening.